Listen closely, because what I'm about to share could protect your life savings and give you back your peace of mind. Just last month, a 78-year-old woman, let's call her Carol, sat in my office. She was a retired school teacher, recently widowed and living on a fixed income. And she had just drained her savings account of $7,300 to pay a debt collector. The letter she received looked intensely official. It was printed on heavy paper, cited obscure state, statutes, and threatened a lien on her home. The debt was for a credit card her late husband had taken out years ago, a card she hadn't even known existed. Now, Carol is a sharp, responsible woman who paid her bills on time her entire life. She built a good life with her husband, and the house they shared was more than just brick and mortar. It was a testament to their 50 years together. But fear took over. She told me, with tears welling up in her eyes, I was terrified they would take my house. It's all I have left of him. She imagined a foreclosure sign in her front yard, the shame of being forced out of the home where she raised her children. So she did what any responsible person would think they had to do. She paid it. And here's the part that makes my blood boil. Carol didn't legally owe a single penny of that debt. The law was completely on her side, but the collectors knew she wouldn't know that. They didn't lie about the debt existing. They simply relied on her fear and her sense of honor to pay a bill that was never her responsibility. They counted on her not asking the right questions. They counted on her being alone. This video is for every senior who has ever received a threatening letter or a scary phone call and felt that knot of fear tighten in their stomach. It's for anyone who has stared at a final notice and thought, I have to pay this or I'll lose everything. It's for the millions of Americans over 60 who are targeted every single day by a system that has become incredibly complex and, at times, predatory. Debt collectors, aggressive lenders, and sometimes even misinformed family members often rely on one powerful weapon, the belief that you won't know your rights. They hope you'll comply out of fear or out of a deep-seated moral obligation to settle accounts, even when those accounts are not legally yours to settle. They are counting on your good character being used against you. But today, I'm here to be your advocate. My name is attorney's name, if applicable, or leave generic, and I'm an elder law attorney. For over 20 years, my entire practice has been dedicated to one thing: helping seniors protect their assets, their independence, and their dignity. I've sat across the table from people just like Carol week after week, and I've helped them fight back. In the next 20 minutes, I am going to walk you through 5 specific types of debt that seniors are relentlessly pressured to pay, but that you may be able to legally and ethically walk away from. This isn't about avoiding responsibility. This is about understanding where your responsibility actually ends and where a collector's scare tactics begin. And you absolutely must stay for the 5th one. It's not a typical debt you'd get a bill for in the mail, but it's the most emotionally manipulative trap I see seniors fall into almost every single week. It preys on your love for your family, and it can be financially devastating. So please grab a pen and paper. If any of what I've said so far sounds familiar, if you've ever felt that pressure, share your experience in the comments below. You have no idea how much your story can empower someone else who is feeling alone right now. And if you find this information valuable, please hit that like button. It tells the system that this is a vital message, and it helps get this video in front of more people who desperately need to hear it. All right, let's dive in. The first and most common pressure tactic, the one that brought Carol into my office, is what I call the surviving spouse trap. It almost always involves the medical debt of a deceased loved one. Here's how it works. After the funeral, after the casseroles stop coming, when you are at your most vulnerable, a letter arrives. It's from a hospital or a collection agency, and it's a bill for your late spouse's final medical care. The amount can be staggering. The letter is worded very carefully to imply that this is now your responsibility. The trap is built on your grief and your sense of duty. Of course, you want to honor your spouse's obligations. The collectors are counting on this. They are counting on you not knowing the fundamental legal truth. In the vast majority of states, you are not personally liable for the separate debts of your spouse, including their medical bills. That debt belongs to their estate. Think of the estate as a separate financial entity. If your husband's or wife's estate has money, the bills get paid from that. But if the estate has no assets, which is very common, then the debt simply goes unpaid. The creditor cannot legally come after your personal savings, your Social Security income, or your home to satisfy it. There are exceptions in what are called community property states, but even there, the rules are complex. The crucial point is this: the collectors want you to skip the estate process entirely and pay them directly from your own pocket. They want you to do what Carol did: voluntarily take on a debt that was never yours to begin with. So, what is your action step? It's simple and it is absolute. If you receive a medical bill addressed to your deceased spouse, you do not pay it. You do not call them and promise to pay it. You do not send them $50 as a sign of good faith. Your first and only move should be to speak with a qualified attorney. Never, ever use your own money to pay a deceased spouse's debt without professional advice. Grief should never come with a balance due. The second debt you can often walk away from is one that seems to rise from the grave. That's why we call them zombie debts. This is a debt that is very, very old, typically 7 to 10 years or more. It could be an old credit card you defaulted on during a tough time, or a personal loan that was written off long ago. You haven't heard about it in years and you've completely forgotten it exists. Then, one day, the phone rings. The person on the other end is friendly, even sympathetic. They'll say something like, "Look, I see you have this old balance of $4,000. We know times are tough. Our client is willing to settle this entire account right now if you can just make a good faith payment of $25 today, just $25, and we can start the process of clearing your name." This is one of the most cynical traps in the industry. Here is the legal truth they are hiding from you. Every state has a law called a statute of limitations for debt collection. It means that after a certain number of years, a creditor loses the right to sue you to collect the debt. The debt is time-barred. They can still ask you to pay it, but they can't use the courts to force you to. That $25 payment, it's a trick. In many states, making any payment on a time-barred debt, no matter how small, can restart the clock on the statute of limitations. That good faith payment just took a legally unenforceable zombie debt and brought it back to life, giving them the right to sue you for the full amount. Your action step here is critical. If you get a call about a debt you don't recognize or know is very old, your response should be scripted. You say, "Please send me a written validation of this debt in the mail." That's it. Do not engage in conversation. Do not acknowledge the debt is yours, and under no circumstances do you give them your bank account or credit card number for a small payment. They are not trying to help you. They are trying to trick you into reviving a dead claim. This brings us to our third debt, and this one is often the most emotionally painful. It involves the debts of your adult children. A collector calls you, a concerned parent, about your 35-year-old son's defaulted personal loan. They might say things like, "We're just trying to help him avoid legal trouble," or "I'm sure you didn't raise him to walk away from his responsibilities." They are pushing your buttons, using your parental love and your sense of family honor as a weapon against you. They want you to feel a moral obligation to step in and rescue your child. Let me be perfectly clear on the legal truth here. Unless you explicitly co-signed a loan agreement for your adult child, you have zero legal liability for their unsecured debts. Your love for your child does not create a financial contract with their lender. You are not their emergency backstop. These collectors know this. They aren't calling you because they have a legal claim against you. They are calling you because they think they have an emotional one. They are hoping you will act as a parent first and not as a person with legal rights. The action step is to draw a firm line between your heart and your wallet. It's okay to offer your child emotional support. You can help them find a financial counselor. You can be a shoulder to cry on, but you are not obligated to sacrifice your own retirement security to fix their financial mistakes. You can say to the collector, "I did not co-sign that loan, and I am not responsible for it. Please do not contact me again regarding this matter." It may feel harsh, but it is the necessary act of self-preservation. You've spent a lifetime building your nest egg. You have a right to protect it. Now, that leads us to the fourth type of debt, and this one is about understanding the shield that the law provides for your essential income. This applies to unsecured debts, things like old credit cards, personal loans, or medical bills, when you are what the legal world calls judgment-proof. It's a term that sounds complicated, but the idea behind it is simple and powerful. The trap here is pure intimidation. A collector calls you relentlessly, threatening to sue you, garnish your wages, or seize your assets. For someone living on a fixed retirement income, the thought of their Social Security check being garnished is terrifying. It feels like a direct threat to your survival, to your ability to buy groceries or pay the electric bill. They use this fear to push you into paying, even if it means skipping a prescription or a meal. But here is the legal truth they will never tell you. If your only sources of income are protected by federal law, a creditor for an unsecured debt cannot touch them. What's protected? Social Security benefits, VA benefits, federal employee pensions, and disability payments are all largely shielded from garnishment by regular creditors. If this is your only income and you don't have significant assets that can be seized, you are considered judgment-proof. This means that even if they sue you and win a judgment in court, they have no practical way to collect the money from you. They can't force the Social Security Administration to hand over your benefits for a credit card bill. So, what is your action step? First, understand where your money comes from. If it's from these protected sources, you are in a position of power, not fear. This doesn't mean the debt magically vanishes, but it means their primary weapon, the threat of taking your income, is an empty one. You can inform them calmly and firmly that your income is federally protected and exempt from garnishment. This knowledge transforms the conversation. It gives you leverage and, more importantly, it gives you back your peace of mind. You no longer have to live in fear of a phone call threatening to take the very money you need to live. And this brings us to the fifth and final point, the one I promised you at the beginning. This isn't a debt in the traditional sense. There's no contract, no interest rate, no formal billing statement. But it is, without a doubt, the most dangerous and emotionally destructive trap I see seniors face. I call it the moral obligation trap. This is when you are pressured, not by a faceless corporation, but by family, friends, or institutions who use your love, your sense of duty, and your generosity against you. Let me give you some real-world examples I've seen in my office. A man passes away with no money in his estate, and the funeral home director looks his 72-year-old sister in the eye and says, "Don't you want to give your brother the dignified service he deserves?" pressuring her to put a $10,000 funeral on her personal credit card. Or a beloved grandchild who is 28 years old comes to grandma and says, "If you don't help me pay my student loan this month, my credit will be ruined. I just need this one time." A distant cousin calls, having made a bad investment, and tells you, "You're the only one in the family who did well for yourself. You owe it to the family to help me out of this jam." The trap in each of these scenarios is the blurring of the line between love and liability. The pressure is emotional, not legal. It is designed to bypass your rational mind and target your heart. It makes you feel that saying no is a moral failure, that you would be selfish or uncaring if you didn't step in to solve a problem that is not of your making. This is where people make devastating financial mistakes, draining their retirement accounts based on a feeling of guilt. The legal truth is simple but profound. There is a monumental difference between a moral feeling and a legal obligation. You have no legal duty to pay for your brother's funeral, your grandchild's student loans, or your cousin's bad decisions. Your desire to help is a beautiful human instinct, but it is not a contract. These pressures are designed to make you act immediately, before you have time to think. And that leads to the most important action step in this entire video. When you are faced with a major financial request fueled by emotion or pressure, your response must be to create space. You must pause. You can say with kindness but with firmness, "I love you, and I hear that you're in a difficult situation. I need some time to think about this and review my own finances and obligations." This simple sentence is your most powerful tool. It gives you the breathing room to separate what you feel you should do from what you are legally and financially able to do, without jeopardizing your own security. It allows you to move from an emotional reaction to a thoughtful decision. Your life savings are not a community bank for the rest of the family. You earned it, and you have the right to protect it, even when it's hard. So today, we've walked through the financial minefields that are laid out for so many seniors. We've talked about the pressure to pay a late spouse's medical bills, the trickery of old zombie debts, the emotional weight of an adult child's mistakes, the shield of being judgment-proof, and the heart-wrenching guilt of the moral obligation trap. The common thread here is knowledge. The people and companies applying this pressure are not counting on you being a bad person. They are counting on you being an uninformed person. They are betting that your sense of honor, your grief, or your love of family will make you act before you have a chance to think. Your financial security in retirement is not a suggestion. It is a right you have earned over a lifetime of work, saving, and sacrifice. Before you ever pay a debt you're unsure about, before you drain a savings account out of fear, I want you to promise yourself you will do one thing. Pause. That's it. Just pause. Do not act under pressure. A legitimate debt will still be there tomorrow, but a moment of clarity can save you from a permanent mistake. Verify everything in writing. If a phone call or a letter makes your heart race and your stomach clench, that is your signal to stop and step back. If it feels wrong, it probably is. Seek advice from a qualified professional, not from the person who is demanding your money. You've worked your entire life to build a secure retirement. You have weathered storms, raised families, and contributed to the world in countless ways. You have the right to defend what you have built. You have the right to say no. You have the right to peace of mind. Please share this video with a friend, a sibling, or a neighbor over 60. Forward it to someone in your church group or your book club. You could be saving them from a costly, heartbreaking mistake, and you might be the only person who will. Thank you for taking the time to protect yourself today.